oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll hear argument in 3 cases this morning. The first is 240102 JPMorgan Chase Bank versus the City of Corsicana and Navarro County from Navarro County and the 10th Court of Appeals. The second case is 240840 DV versus the Texas Department of Family and Protective Services from Hays County and the 3rd Court of Appeals. And finally, 240293 INRI Graystar Development and Construction, a mandamus petition from Dallas County and the 5th Court of Appeals. The court has allotted 20 minutes to each side in each of the arguments. We'll take a short break between the arguments, which can be viewed online and will be available on the court's website later today. We're ready for argument in 240102 JPMorgan Chase Bank against the City of Corsicana and Navarro County.
May it please the court, Mr. Kutnick will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
May it please the court. One of the reasons Texas is known as a business-friendly state is that the Texas Constitution and statutes expressly authorize cities and counties to grant public money to companies for economic development. This case will help determine whether Texas maintains that reputation or whether cities and counties should be allowed to renege on their promises, unilaterally rewrite their economic development agreements years after the fact, and impair vested contractual rights with impunity. To resolve this appeal, the court need not debate the wisdom of economic development grants or decide whether the city and county made a good deal in 2004. Rather, the court only needs to determine whether the agreements here are constitutional. I want to focus on 2 issues today. First, the controlling constitutional and statutory provisions that govern this case and establish that these agreements are constitutional. And second, even assuming the 3-part test from Texas Municipal League, or TML, as recently reformulated in Borgeld applies, why the grant here easily satisfied that test, because among other reasons, the grant here was uniquely structured so that the tax incentives would flow only if there was actual economic development and business activity that generated sales tax for the city and county. The starting and ultimately ending point for the analysis should be the Texas constitutional provisions and statutes that govern this case. The constitutionality of economic development agreements is governed by the 1987 enactment of Article 3, Section 52-A of the Texas Constitution. That section unambiguously provides that notwithstanding any other provision of this Constitution, the legislature may provide for the creation of programs and the making of loans and grants of public money for the public purpose of development and diversification of the economy of the state.
So when you say notwithstanding any other provision of the Constitution, the legislature authorized such a program but limited it to a particular racial group, and we say, well, that part of the Constitution has been set aside, the legislature can do it.
Now, Your Honor, I think the notwithstanding clause only applies to provisions that are inconsistent with this Section 52A, -A. And one of those sections would be Section 52, because Section 52 prohibits, it's absolute, it prohibits grants of public money to individuals and corporations. And the notwithstanding clause in Section 52-A trumps that and says, despite what that section says, you can do it for economic development purposes.
So then the rest of it, though, would still be in place, I would take it, though. Nothing about 52-A would stop the rest of the requirements from applying. We just now say, just so everybody knows, this is not something that's categorically prohibited.
I guess I need to look, when you say the rest of the requirements of Section 52 or the rest of the Constitution?
All the remaining gift clause requirements.
I don't think so, Your Honor. I think.
But what in the text tells us that? I don't understand your argument.
The notwithstanding.
Too far or not far enough?
I think the notwithstanding clause tells us that. I think the other thing, if you look at.
Notwithstanding something. It has to be notwithstanding something.
Notwithstanding the prohibition of granting public money, which is in the gift clauses. I don't view section 52-A as a gift clause. Unlike the gift
Well, it
clause.
says for the public purpose, that it says development and diversification of the economy is a public purpose. Okay, great. That's one element of the gift clause test.
Well, if you look at section 52 and the other gift clauses, public purpose is nowhere in them.
It's in TML and in several of our cases from before that the legislature and the people were presumably aware of, like Bullock versus Calvert from 72. So why shouldn't we assume that they knew exactly what they were talking about when they said this is a public purpose and that's all they intended to address?
Because if you look at the section 51 gift clause, there are a lot of enumerated exceptions to that gift clause in section 52. None of those clauses have a notwithstanding clause. In fact, some of those clauses have a subject to the limitations herein. And so that's, I think, legislative intent, that those sections, to the extent there was, I mean, you also got to remember section 52-A was enacted 15 years before TML.
But not before Bullock versus Calvert.
Right, which just talked about public purposes and maybe
Right,
public benefits.
which is exactly what 52-A is talking about.
But those provisions are really baked into the statute and the Constitution provision itself. If you look at section 52-A, it also says, for example, if you have an economic development program that's based on ad valorem taxes, you need a vote of the majority of voters to do that. The statute itself also has various restrictions or limitations. It has to necessarily be for economic development purposes. It has to stimulate business and commercial activity. The legislature also put in other provisions in 2021 where the local development agreements, which necessarily implies some type of non-gratuitous grant, has to be filed with the comptroller and contain all sorts of information.
Why wouldn't the public purpose language in 52-A sort of pull in the same sort of concerns that are animating the pre-existing gift clause test?
Because I think the notwithstanding clause is trumping language. I mean, if you wanted to pull in any pre-existing restrictions, I think the clause would need to say, subject to these restrictions.
Well, it looks to me like the three-part test that pre-existed from Borgelt and the other cases is essentially getting at, is this really for a public purpose or not? And then you have the requirement in 52-A that it be for a public purpose. It seems like you'd have to do something similar, maybe not the exact same thing, but some kind of analysis other than just we're going to stamp economic development on it and there you go.
Well, I don't think you can just stamp the words on it. I think the other thing to think about is section 52-A itself, section 52 gift clause, itself has an exception. It has an exception in subsection A that allows for payments for various insurance premiums. And then subsection B has also sorts of exceptions that allow grants based on a vote of 2/3 of the majority of voters for things like building of pools and dams and roads. If the legislature wanted economic development to be subject to whatever restrictions were on the gift clause, they could have just amended section 52 and put economic development in there. And that's not what they did. They created a whole new constitutional provision and started with notwithstanding any other provision.
Well, could it just be more of a directive that economic development is a kind of acknowledged public purpose, but that says nothing about whether there should be an inquiry into whether the contract, the program, meets that public purpose of development and diversification of the economy. In other words, it's just saying diversification of the economy, economic development can be public purposes. It's nothing about it says that any particular program must be.
Your Honor, I think the ultimate test for whether it's constitutional is look at the Constitution. Does the Constitution allow it? And here, we don't have anything that prohibits an economic development program. We have a constitutional provision that specifically authorizes, and I think that's the ultimate test.
So what would you say I mean, you just admitted that you couldn't just stamp economic development on it and call it good. So to Justice Bland's question, what should the test be under 52-A that's different from TML and Borgelt to decide, is this a grant that serves that purpose?
Well, I think you got to go back 90 years ago to this court's opinion in Davis v. City of Taylor, and it said, what is a public purpose is for the governmental body to decide, and we're going to give a lot of discretion. And unless a court can say that the purpose is clearly not a public purpose, then a court should not be able to invalidate that determination.
Well, we know it's a public purpose. The question is whether this development serves it.
Well, I think you look at kind of the hallmarks of what economic development program should be. It should be something that would either lead to business growth or business relocation, increased jobs, or increasing the tax base.
If there was a program where the same money was raised and it was just anybody who's opens up a business in this area, we're going to have a drawing, once a month, and you get $150,000 if your ticket is pulled. Would that be an economic development program?
I guess it depends. I think the economic development agreement or program, I think under the statute requires an agreement. And so if under your
No, we're talking
hypothetical,
about the Constitution.
if you just gave $150,000 for.
Yeah, somebody opens up a business in the area. We're trying to attract businesses to come to the area. And so here's a great idea. Come open an ice cream shop, open a sporting goods or whatever. And once a month or whatever, we're going to have a drawing for anyone who opened the business, and if your ticket is pulled, you get $150,000.
No, because I think the court is subject to judicial review, any of those decisions, and I can't.
What would the judicial review say is wrong with that under your test?
Because I don't think giving $150,000 to somebody who walks into the store necessarily, it doesn't.
No, it's a business owner. They had to open a business in the area.
Because I don't think it would achieve any goal that
Does it incentivize people to open a business there?
I think you start with the presumption it's constitutional, and if the party challenging the expenditure can show that it's not for a constitutional purpose, if it's not for economic development, if it's really for a private benefit, if it's to give a gift to a big donor, then I think the courts would have the ability.
What if they could show there weren't sufficient controls?
I don't think the sufficient controls is part of the.
You mentioned private benefit. That's one of the tests. Public purpose is one of the tests. You agree with that? The only one that's left is the controls.
Yeah. So look, in my view, controls is not in the Constitution. It was a way to wire around the gift.
Indulge us and assume that the court's
Yes.
been right in saying that all these years. What would your argument be if the court decides to stick with that and conclude that that's a showing that's needed? Can you win, or do you lose if we just reaffirm that precedent?
We can win on if we.
And that's what I want to hear.
Yeah.
What would satisfy the controls test if that requirement?
On your hypothetical?
No. Let's just get to yours.
Okay.
Yeah.
Well, look, I think the fundamental thing you got to look at when you're applying the TML-Borgelt test is what was the public purpose, and what was the public purpose back in 2004 when the agreements and resolutions were passed. And here, that's kind of where the Court of Appeals went astray, because what the Court of Appeals did is rather than apply the test to the public purpose that the city and county actually articulated in 2004 when entering the agreements, the Court of Appeals disregarded that purpose. It impermissibly rewrote the agreements and then determined whether the transaction was structured to ensure that a different public purpose, as reformulated by the city and county and courts years later, would be accomplished.
Well, I'm talking about the controls section. So let's assume that you're right about the public purpose should be measured at the time the transactions. That's what you're saying,
Yes.
there, right? That sounds reasonable enough. What were the adequate controls under our precedent that would prevent this from being a gift clause problem?
Well, in this case, you start with the public purpose, and the public purpose is you look at the resolutions. It was for the development and construction of a retail center.
Okay.
And that's what the contracts here required the recipient of the funds to do. It required the foundation to obtain a $10 million construction loan. It required the foundation to build a retail center, and it required the foundation to provide regular reports how it was using the public funds and the loan and to update the status of construction. That is control. In fact, under this agreement, under Section 7 of the interlocal agreement, the city and county had no obligation whatsoever to pay any money until the retail center was completed.
Well,
There were payments made, and then the payments stopped, right?
Yes, after Gander Mountain opened, payments were made for 11 years.
So, looking at 52-A, could you read this to say, may provide for the creation of programs and the making of loans and grants of public money? Should we think of each payment as a grant of public money that has to be for a public purpose? And so for a certain period of time, those grants were for a public purpose, and then the store closes and the city's no longer getting anything for its payments, and so they're no longer loans and grants of public money for the public purpose of economic development. You look at each payment separately.
I don't think
as
so.
opposed to looking at the whole
I think
contract.
that would lead to chaos, and it would lead to arbitrary line drawing. Because what would stop a city and county from, however many years down the road, saying, Gander Mountain isn't selling as many fishing pools as we'd wanted, so we don't think there's a public purpose. Or Gander Mountain isn't open 24 hours a day. We want our public purpose, even though it's not in the agreement, is we want a store open 24 hours a day. No public purpose that we pull the strings.
The Constitution doesn't say anything about contracts, right? It doesn't bind them to contracts, right? It just authorizes them to make grants for the public purpose of economic development. And so I don't know, it's not obvious based on the constitutional text that the contract really comes into the analysis at all.
No, but I still think you got to look at the public purpose at the time. And if the public purpose was a construction, and they've achieved that public purpose was achieved 21 years ago when the store was developed and all the surrounding development. And from a factual standpoint, there is still a public purpose.
And so my question is the loan or grant of public money to which the Constitution is referring the creation of the contract and the entry into the deal, or is it each periodic payment is the grant?
I think it's the former, because the Constitution allows the legislature to provide for programs. And so you got to look at the program, not each individual payment. I see I'm out of my time.
Any further questions?
Just one. I think you characterized this court's three-pronged test as having wired around the text of Article 3, Section 52. Do you think that there's any basis in the text itself for that test?
No, I don't, because if you read Section 52, it's absolute on its face, other than the exceptions that are in the text itself. And so if it is a grant of public money to an individual or corporation under Section 52, I think it is prohibited.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Jacobson will present argument for the respondents. Mr. Mendelson will present argument for the amicus. Mr. Jacobson will open with the first 15 minutes, and Mr. Mendelson will present with 5 minutes.
May it please the court, my name is Terry Jacobson, and I'm here to represent the city of Corsicana and Navarro County, along with Tyler Talbert and Rory Ryan. Part of the fundamental problem in this litigation has been that the petitioners have treated all this litigation as litigation involving private contracts between private parties, where parties can allocate risk as they see fit, inject capital as they see fit, depending on what they think the return might be. That's not the case when you contract with the public entity, a local government, and economic development. You have 6 different gift clauses, which are well established within our Constitution, that require a different analysis. And TML overlays every contract, economic development contract that is, with the requirements of what you can do or what you have to do in order to earn the public's money, to protect the taxpayers' money. The control element, which you raised, Chief Justice, it's absolutely critical to all of this. The control element does a couple of things that are very important that makes this system function efficiently. For example, it links the public benefit to the incentives that are given. It creates a tie between the two. In the absence of a control, there's no way to ensure is this court's word, to ensure that the public ever gets anything. I say the public, it's the taxpayers. I mean, it's my money. I live in Corsicana. When I go to Home Depot, it's my money that I'm paying to Home Depot that would fund this deal. So it does that,
So
which is
the
critically
control
important.
is one aspect of a check on the allocation of risk that you say is, and private parties can be whatever the parties agree. But counties and cities can take on contractual obligations that involve risk allocation. And here, are we to look at what control the contract had within it, or what control the city did not, but perhaps could have exercised?
Absolutely. You look at the contract. There's a Fifth Circuit case, the precision ammunition case, which I believe you cited in Borgelt in your concurring and dissenting.
And so in
opinion.
Borgelt, the contract had controls over the expenditure of the public money in connection with a collective bargaining agreement. But the city perhaps had not done the job that it should have done in enforcing those controls throughout the duration of that agreement.
I would say it a little bit.
Is that what's happening here, or is this contract just completely devoid of the ability of the city to control?
This contract is completely devoid of controls. It's completely devoid of controls. The second thing that the controls do.
Well, it does say the tax funds have to be used to pay off the loan, right?
Do what?
That the taxes that are being paid, the redirected tax funds could be used exclusively for paying off the construction loan?
Yes.
Is that right?
That's it, yes.
Okay.
But the controls are more than just that.
So on that point, though, I don't understand the idea that there's no link here. The payments don't start until a construction has been undertaken or maybe even completed. So why isn't that a link? That seems like a condition.
The payments only began to be paid once the building was open. But opening the building is not the public purpose. If you look at the interlocal agreement, you find the first page at the 4, the clerk's record, 892. It shows us exactly what the public purpose is. Contractually, it lines it out. It begins on page 892 talking about stimulating business and commercial activity in the city. And then it narrows it on the next page. In the 7th whereas clause, it talks about developing a retail facility, little r, little f, that's later defined, or actually defined in that same sentence, as the Gander Mountain facility. The next page, which is page 894, the interlocal agreement says the city and county have determined it's in the public interest to promote the economic development of the Gander Mountain retail facility. The economic development goal here is not the creation of a building that the city and county never received. It's actually what happens in the building. It's economic development. And in a retail facility, by definition, the only thing you would ever do to create economic development would be to sell stuff. That's what it's for. So,
and the only thing that would generate the taxes, that's the only thing that would generate the taxes that were going to be used to pay off the loan.
Generate taxes, create employment opportunities. The taxes would be also sometimes ad valorem taxes, although in this case, there was actually a tax increment funding district in place that overlaid the whole thing. And so the ad valorem taxes the city and county actually received were basically deferred until after the TIF was completed, which was last year, the 20-year agreement.
Your test sounds like hindsight, though, that no one could determine at the outset of the contract whether it violated the gift clause or not. But 10 years later, the county could come back and say, well, it does because we didn't get the foot traffic that we anticipated, which is what's happened here.
Well, first of all, we're not only not getting foot traffic, we're not getting anything. So it's not a situation where there's a gradation of benefit we receive. Yeah. But I think actually TML was in place when this agreement was signed. It was already there. And you have multiple attorneys general from Jim Maddox up now to Ken Paxton who all agree about the TML test and what Section 52-A actually does. There was plenty of authority out there already telling the parties exactly what you needed to do to have a constitutionally compliant agreement. And in this particular case...
Is the crux of the test you're proposing really that there must be a clawback provision, there must be a mechanism for the government to get its money back, and that is a minimum requirement for any of these to pass muster?
That's one of the minimum requirements. The other is there has to be actually some
You're not suggesting
metrics.
that you would have to get the sales taxes back during the period that the store was open and operating, are you?
I'm sorry, Your Honor?
You're not suggesting that you would be able to claw back the sales taxes for the time that the store was actually open and operating, are you? I thought your complaint was that public money didn't cease being paid once it was no longer operating.
And that's exactly how we functioned it. The city and county contributed money to the sales tax fund, to the blocked account, which went to JPMorgan Chase, for every quarter where we actually received something as a result of the opening of the Gander Mountain store. We are not looking to retrospectively reclaim the money that was previously paid. We think the contract was always a void contract.
Well, if it was always a void contract, could you not have, as soon as they went into business, said, it turns out that even though the city and county entered in this contract and we thought about it, void all along, so, too bad, we're getting everything back, we owe you nothing. Couldn't any city now, if the Court of Appeals is right, in other words, seek to get all the benefits from the development and have none of the consequences?
Candidly, we thought about it, but it wouldn't work. And here's why. Even with the void contract, the principles of equity of restitution would still nonetheless provide the JPMorgan Gander Mountain Foundation people with a defense to any attempt to claw back everything. And what you would actually measure would be the benefit received by the city and county while the contract was being performed. I think the example in the restatement of restitution, which I didn't realize there was one until this case, that restatement itself gives a hypothetical about a woman who lacks capacity, and she hires a painter to paint 3 houses. After he paints one and gets paid for it, the relatives of the woman say she lacks capacity, the contract's void, and basically, does the painter get to keep the money for the first house? And yes, he does. He gets to keep the benefit that he conferred upon the lady to start with. So it's not a situation where we get to say we want all of our money back. I mean, again.
What if you had gone in 6 months after it was built and just said, it's void, so yeah, we're not going to claw back 6 months of it, but no more from now on, no more sales tax going to repay this. We can't pay for an unconstitutional agreement that we ourselves created and entered into. That would be terrible.
Well, it wasn't just us that created it. I mean, the foundation and the bank and Gander Mountain all had counsel as well. So,
but what would stop a city from doing that? Let's get you in. Sure, maybe you're right about the equitable interest and the clawing back. Would that likewise mean that you could go forward in time? Like that seems tricky to me. If it's actually an illegal contract, to say that the city must continue to comply. It would have been a void contract,
but it's highly unlikely that would have happened. I think what would have happened was the parties would have negotiated a constitutionally compliant agreement. We obviously wanted Gander Mountain there. I mean, we thought it would be helpful to the community to create economic development opportunities. What would have happened, I think, is we would have sat down and created metrics that Gander Mountain had to produce, and then clawbacks that we would have received had they not produced it. And the beauty of the controls, if they're done correct, adequate controls, is that all of this gets taken care of or resolved within the confines of the contract. It doesn't create constitutional problems for this court to resolve.
Why isn't ceasing payment, as you did, an adequate control?
It wasn't actually in the contract to do it. We had to actually call upon the gift clauses in the Constitution and the TML test to effectuate that. That's what we filed.
What's inadequate about that as a control on making sure that the public purposes continue to be achieved?
It's extra contractual. We had to actually reach outside the contract and pull in.
But why is that inadequate as a constitutional matter to allow you to control whether or not the public purposes are being achieved?
We don't think it is. We think that's our remedy. That's why we're here, is because we filed that lawsuit. So it's not within the contract itself.
So then, why is the contract void if you can just stop payment whenever you want to, and that solves the controls problem?
Because under this court's precedent, the contract doesn't contain adequate controls to ensure that we receive something in return.
So if you had just stopped payment and they sued you without you having filed litigation, I guess, would you think that they could recover? They could compel you to continue paying unless there were a gift clause problem?
If there are no gift clause problems, yes. I mean, then the contract is the contract. That's why we're here, though, is because we went and sought I guess it's actually delayed given the time period of Gander Mountain's bankruptcy, but we actually sought, of course, court validation of our actions, which I think is the responsible thing.
And so you would say, even if there's no dispute at all, that this is all going beautifully and the public purposes that we all imagined are being achieved, and there's no dispute as to whether it's going exactly the way both sides wanted it to go, and that is achieving a public purpose, you could nevertheless just say, there's no section in here on controls, and so
But why would we do that if nobody has
Pull the rug
it?
out from under you. But you're saying that that's an option you have at any time, is to just say there aren't enough controls and pull the rug out?
If the Constitution, if the
Even if the controls aren't at issue?
If the contracts, well, if the controls are not at issue, then we have to perform the contract, assuming that you have also a public purpose
But
as well.
if the lack of controls voids the contract, then I would think the consequence of that is that you can pull that rug out anytime you want, under the theory that the controls are inadequate, even if the controls aren't at issue and everybody's happy.
Yes, if the contract is not constitutional, we could walk away from the contract. But again, in the real world, why would we do that? If everybody's happy with their performance, what could have happened and what should have happened, maybe perhaps, was sitting down and negotiating something that's constitutionally compliant, that matches metrics of what you're going to give us with the metrics of what we're going to give you. So there's an adequate, sufficient, equal consideration that's exchanged between the parties. That's what would happen in the real world. And that's also why
If this land ends up being repurposed into something like a Buc-ee's or something where all of a sudden, 5 years from now, you are obtaining sales tax revenues beyond your wildest expectations for this property, what then?
Well, I assume if a Buc-ee's wanted to come to Corsicana, there's one up the road and one
Yeah,
down the road.
I know.
Assuming it did.
But I'm
assuming
just
it did.
saying, as an example, some use of this property which ends up generating sales tax beyond any expectation that this contract would have done. And
What would happen would be the new owner of the building would come in and say, we want to establish a business here. And now, knowing what we now know, we would say, great, what do you propose to do, and how do we measure your contribution?
No, you have no agreement with anybody. The only agreement you ever had was the initial economic development agreement that at this point in time is not generating tax revenue. But 10 years from now, it generates just gobs of tax revenue. Does the whole gift clause problem go away?
I think if the contract was already void, it's already void. But in this world, when somebody is going to come and contribute that much to your local economy, they want something in return. That is the world in which we live. That's how it works. And right now, there's an RV park there. And you're thinking, okay, well, RV park sounds good. That creates some jobs. But here's kind of the part of the problem with that. RVs are considered motor vehicles under the Texas tax code. And you don't collect local sales tax on RVs. So we're glad to have an RV park, but it doesn't benefit us with sales tax. And as I said earlier, there's a TIF in place. It's in the record, and the TIF is a 20-year TIF. And so when a TIF, you take a baseline value of what the property's worth at the time before you create the TIF, and then you dedicate the increased ad valorem tax revenues to the developers, not the Gander Mountain, but to the developers, and the developers then repay themselves their infrastructure costs, their utilities, their road building, that sort of thing. So as it now stands, we don't get anything more than what the dirt was worth to start with. So, but as a practical matter, again, if somebody builds a building that gets foreclosed on, and we end up back in an empty building stage, which it was for a couple of years, and have a new business come in, the fact that there's an old contract doesn't affect the new relationship with the new owner of the building. Whatever they negotiate or ask for, we'll consider it. If they don't ask for anything, then we won't give it to them.
I'm sorry to return to the text of the Constitution. In 52 subsection A, there was this express exception for the use of public funds for the payment of premiums on non-assessable property and casualty, life, health, or accident insurance policies, so pay those premiums. Are you aware, has our three-pronged test been applied as to the payment of those insurance premiums?
I don't believe that it has, and I'm aware of, Your Honor. I tried to look at most of the 52A cases.
Okay.
And if it has, it doesn't affect this court's precedent in TML, the previous cases, all the AG opinions. As I said earlier, if Jim Maddox and Ken Paxson can agree on something, it's got to be the law.
Well, but if you're aware of cases where we have said for the payment of those premiums, no need for controls, no need for public purpose, it's already there, and it's an express exception, then it might matter quite a bit if we haven't looked for those three prongs.
And it would seem to me that would be the case because that exception, I think, was actually enacted well after the Constitution of 1876. It's something that was added later on as an exception to the jurisprudence that grew up around 52.
Any further questions? Thank you, Mr. Jacobson. We'll hear from the amicus.
Thank you, Your Honor.
Mr. Chief Justice, and may it please the court. Last year, the court correctly suggested that Section 52-A did not create a categorical exception to the gift clauses. Section 52-A speaks only to the public purpose requirement of the gift clause test, and the rest of the test remains unaffected. Any other reading would permit government entities to give away taxpayer funds under the paper-thin veil of economic development. Section 52-A's use of the term public purpose shows that it only broadens the public purpose requirement, but not the gift clause test. And we know this because when the legislature uses a term with a very well-established judicial meaning, and Justice Busbee was certainly correct to point out the Jefferson County case, the Crosby case, or I think the Bullock v. Calvert case, all three of those cases have been using that term, and those cases are from the 50s and 70s. So we know that that term was so well established that by the time we get to 1987, it had a very clear meaning.
Your brief cites some cases where we have said that we presume that the legislature is aware of our output in the Southwestern Reporter. Have we ever said that with respect to the people of Texas and whether they are also poring over our opinions and are generally aware of them?
Well, what the court has certainly said is that we interpret constitutional provisions with much the same canons of construction that we interpret statutes with.
And same question that I asked your friend in opposition. Do you believe that our three-prong test is wiring around the text of Article 3, Section 52? Can it be squared with the actual text?
The court addressed that in the Bourgelt case last year when it acknowledged that perhaps the test itself is not the actual words of the Constitution, but nonetheless explained that that still helps to enforce the Constitution's mandate. The court addressed that last year in the Bourgelt opinion, and the state, as an amicus, certainly doesn't want to inject an issue into this case that the parties have not raised. I think it's also very important to remember that JPMorgan's argument, if accepted, would really be an implied repeal of the gift clause test and of all of the gift clauses. And what I mean by that is exactly what this court said. This is on page 647 of the Uplift Harris opinion last year, where it said if that argument is correct, then Section 52-A comes close to repealing the gift clause's ban on gratuitous payments to individuals. Justice Young pointed to a hypothetical about what if there was a lottery, and if you won the lottery because you opened a business, you would get $150,000. The problem, of course, with that is that there would be no controls in that situation. And Section 52-A is written so broadly that if all a government entity has to do is say, this is for economic development, or this is for the development of commerce, which is another incredibly broad term that is in Section 52-A. If all a government entity has to do is announce that those are for commerce, or whatever government program is at issue is for economic development, then the gift clauses are effectively impliedly repealed.
The other things in Section 52A that are allowed, because it's not just economic development, but it's the elimination of unemployment or underemployment in the state, for example. Do you think that if we were to have a pretty rigorous approach to what controls are adequate, that we would be jeopardizing, casting serious doubt at least, on a lot of statutes that have created programs that the legislature has thought served the interest that 52-A identifies?
No, I don't. No, I certainly don't think so. I think that this court's jurisprudence from the TML test and the Bourgelt test have talked about what adequate controls means, and I think that's pretty well developed. The state as an amicus certainly doesn't want to take a position in this case about how much of a control is adequate or what is enough of a control.
Well, would the state agree that the hypothetical that you were just describing is worlds away from what actually happened in this case, where the money was only available based upon the actual economic development at the place that the loan was? I mean, it seems like they're not going to get any money unless economic development actually happens, whereas just here's $150,000, small business, big business, been there for a long, that seems like just perhaps a gratuitous transfer. The link to the economic development is so attenuated, whereas what happened here doesn't seem that attenuated.
The state doesn't want to take a position on the facts of this case or how the gift clause test applied. What I will certainly point the court to is the Uplift Harris opinion, which talked about how if it is really a no strings attached payment, if there's really no way to ensure that a public purpose is achieved, then that would certainly be a controls problem. But the state as an amicus doesn't want to take a position on the facts in this case.
Setting aside this case, often there are periodic payments set up in these arrangements. Would the a city's ability to cease periodic payments if it decides a public purpose is no longer being served be a sufficient control, irrespective of what the contract says?
No, it would go to, is the public purpose being achieved? Is there a way that we can tell if the public purpose is being achieved? But again, the state in its brief took no position on what the facts of this case or whether this was an adequate control.
Does the state have a position about whether the consequences, the unintended consequences, I suppose, of allowing local governments out of their agreements, what consequence that could have in terms of banks just say, well, fine, then we're not doing this in Texas, or the costs to the public go way up because there's always this risk that some local government's going to say, change in administration, the new mayor comes in, whatever, didn't like that program. We don't think the public purpose is being, we're going to stop payments, and they have to go into litigation. Is that not the foreseeable consequence, and what's the state's view of that?
So I guess what I would speak to is I think the court is referencing both the public purpose and the controls requirement in the court's hypothetical. As to the public purpose requirement, what I would say is in the Borgelt opinion, the court explained that the public purpose requirement is somewhat deferential to government entities. And in Borgelt, the court explained that we begin with the presumption that if a state entity says, I see I'm very much out of time to answer the court's question. The court explained that effectively implying the presumption of regularity in the gift clause world, referencing cases like Annunciation House and Webster from last term, that we begin with the idea that there's a presumption of regularity and it has to be pretty clearly rebutted. In other words, I think the court explained for the reason of the separation of powers that the public purpose requirement should be somewhat deferential. As to the controls requirement, without commenting on the facts of this case, I think what I would say is, although the controls requirement is certainly a spectrum, there's an example from the Uplift Harris opinion on one end about what is truly no strings attached, which is easy to police. Maybe an example for the court's attention of what the state thinks is an adequate controls requirement on the other end of the spectrum might be something like the SNAP, the Supplemental Nutrition Assistance Program, where a debit card can be stopped from being used at a register.
Would the
I think
same
that's a good
point
spectrum.
that you made about the presumption of regularity, presumption of lawfulness, all the rest of it, not apply to government's determination that adequate controls exist, as that it's a public purpose?
I know the presumption of regularity would certainly still apply. I think what distinguishes public purpose, though, perhaps from others, is when the court was referencing the separation of powers, I think it's referencing, I'm very much out of time to answer the court's question, thank you, that courts should not be, particularly as applied to Section 52-A, engaging in maybe a good term is backdoor Lochnerism, the idea of saying, is this really economic development? Is this really for the development of commerce? A very broad term, of course, from the federal court's jurisprudence. I think what might distinguish public purpose is having courts closely analyze, is this really economic development or is this really commerce, might get the court into the Lochner mistake.
So we'd be reasonably deferential there. And I just, one last thing, and this relates to a question Justice Bland had raised earlier, and that is, assuming that we are reasonably deferential to another branch, local government, whatever, about those kinds of determinations, there's a problem if we're being deferential to their determination at the time that the transaction is entered, or if we're looking at it when they decide they no longer like the transaction. Now, we think there isn't an adequate public purpose, or we think there isn't adequate controls. At what point should that deference be given? Because they're now at war with themselves, the same entity that entered into the contract, thus presumably saying, we think all of these things are satisfied, now saying, oh no, it was void all along, or what the controls that we ourselves signed on to are inadequate. At what point do we defer to the decision of the coordinate part of the government as to those features?
Again, the state's a little hesitant to take a position on stuff that it didn't brief, but I think what I will say is I think that's a very fact specific question. It would depend. It would depend, I think, on the facts of any given case.
Any further questions? Thank you, Mr. Mendelson. Mr. Kutnick, you have 5 minutes.
So on your point about the what is the public purpose that we judge the adequacy of the controls against, why isn't the fact that the redirected tax funds being used to pay off the construction loan through the life of the loan an indication that there was a purpose to have the store operating and not just constructed?
Because it's nowhere within the resolutions or the agreements. If you
Well,
look
your
at.
friend on the other side said that the ILA says this is to stimulate commercial activity.
Correct. And Your Honor, I think one of the things, the beauty of this grant is that it's self-regulating. If the retail facility, 87,000 square feet, is never built, which in and of itself provides economic benefits because there's going to be property taxes on that building in perpetuity. But apart from that, this is not a grant where the city and county are reaching into their pocket and giving money to the foundation. The only money that goes to the foundation is when there are sales from the new retail center and the surrounding development.
And that's exactly my point, is that they're looking for sales. They're not just looking for a building.
But not just the sales from this one store, the sales from the surrounding development that wasn't there, that this new retail center was going to spur that development, and that's what happened.
But the fact that some of the tax revenues were going to be from this store seems like an indication that that was one of the purposes, that they wanted the taxes from this store to flow to pay off the loan.
Look, I don't deny that might be an incidental benefit of it, but again, if the store is closed, and council correctly acknowledged, it is not closed. There is an existing retail facility there, and in addition to RVs, they also have a store there that sells camping equipment, and there's a restaurant in there, so there is still sales tax. But there's still also sales tax from all the surrounding development. And if those stores aren't developed, if they don't generate any sales, the city and county aren't out any money. That's the ultimate control in this case. If there's no economic development, there's no incentive paid. If there's no retail center that's built in the first place, there's no incentives paid. So the city and county are getting their cake and eat it too. I think on the controls, my friend on the other side, he said it's completely devoid of controls. I'd ask this court to look at bench exhibit number 3, because this agreement has all the controls that the AG's office and the city and county's own authorities say that you should have in an agreement. The AG says a contractual agreement outlining requirements that the receiving party must comply with in exchange for the fund may provide sufficient control. We have that here. We have 3 agreements that required the foundation to do certain things, including building a store. The AG has also said that an agreement providing for an annual accounting of the funds may be used to satisfy the control prong. We have that here. Every quarter, the foundation had to provide written reports to the city and county saying how the funds were being used and the status of construction.
I'm struggling with why, in a periodic payment situation, the ability to withhold future payments is not a sufficient control in and of itself. And I wonder whether the controls prong is talking about when you've already handed the money over, what control do you retain over what they do with it? But that's not really what we have here.
We don't have that here because of the unique nature of this grant. And unlike, I think Justice Huddle raised a clawback provision. A clawback provision might be a provision you would put if this were a case where the city and county, instead of paying when they receive sales tax, and remember, they're only paying a portion of those sales tax back to the foundation. They're not taking everything they get, just a portion.
Well, $1 is enough for a gift clause violation, probably.
No, I understand, but it's also showing that there's an economic benefit because they're also keeping part of it. And so it's not an unconstitutional grant. But unlike that situation, here it's self-regulating. So when there's a benefit to the city, the foundation is also getting part of the incentive.
So if the city had just promised, like, we're going to pay you this much, you do this thing, and then every year we're going to give you out of the general fund a certain amount, a clawback would be the kind of control that's required. But if it's tethered to, you're not getting anything unless the very thing that we're trying to encourage, it produces fruit, you don't need the clawback?
Exactly. I mean, if this was a case where the city and county gave $10 million up front to build the building, and then there was no public purpose, no control, then maybe that's a situation where you have a clawback. But when you only are paying the money when there's actual economic development and sales, then there's no need for clawbacks or recapture provisions.
Or there's nothing to claw back, I take it as your point.
Right, because if there's no sales, they don't owe anything. If none of the stores sell anything, they don't owe.
Well, the Home Depot was pre-existing, so it seems like it's a little bit divorced from this, what they were trying to incentivize with Gander Mountain.
The record doesn't necessarily support that. I think there is a line in the at the time of the interlocal agreement, which was in May, the Home Depot was under development. There's nothing in the record that shows what the status of the Home Depot was in February when they first entered into these
This agreement is not to incentivize the Home Depot. The point is they're getting tax revenue from something that's not necessarily connected to this project.
Well, we don't know that from this record, Your Honor.
If that were the case, if it were established though, then you could perhaps concede, well, that part of it maybe would be necessary. to call back.
That might be a closer call. There is a severability clause in the RCDA, so if there's a problem with giving money from the Home Depot, that part of it could be severed out. Unless there are any further questions, I would ask.
Any further questions? Thank you, Mr. Kutnick. Thank you to all counsel. The case is submitted and the court will take a brief recess.
All rise.